The clerk will open the court.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
Good morning. The COVID-19 pandemic required many adjustments of the justice system. Social distancing and group size restrictions, as well as substantial hardships on counsel traveling to Austin, do not allow us to hold arguments in the courtroom. Rather than submit cases without argument, we have decided to proceed through remote connections. Court staff has made every effort to prepare us and counsel, but of course there may be glitches that will require patience. Otherwise, we will proceed as we would in person. The arguments are being live streamed this morning, and a recording will be available later today. We are ready to hear argument in cause number PD-1096-19, ex parte, Christopher Rion.
May it please the court. My name is Josh Vanderslice, and I represent the state of Texas in ex parte Christopher Rion, a pretrial habeas appeal from Dallas County. The question in this case is whether appellant can be tried for aggravated assault after he has already been acquitted with a manslaughter of a separate victim arising from the same transaction. State requested review in this case and asked this court to reconcile the way Texas does culpable mental states in its penal statutes with ASH-based federal double jeopardy collateral estoppel jurisprudence. This court can do that today by sticking to its opinion in Adams, and which recognized the importance of the jury charge. The jury charge is what ensures that the verdict is lawful, and by ensuring that the verdict is lawful, it ensures that any fact that is necessarily decided has been decided as a matter of law as necessary for issue conclusion. Appellant's position, as adopted by the Court of Appeals, was that prosecution is stopped because the culpable mental states of manslaughter and aggravated assault are the same. That's wrong for two reasons. First, culpable mental state was not the only rational path to an acquittal in the manslaughter trial. Second, the culpable mental state question is different in the second case.
What other path to an acquittal in the trial was there besides assuming that this was the same fact that was decided in the two cases?
So there are a couple of other paths to acquittal. The most obvious one would have been causing the death. And there are a few different legal ways you could have gotten there based on the shaky evidence that the state presented of how the victim in the first case actually died. She goes to the hospital. She dies, I believe it's 4 days later. And they have already done some medical work. They've reset her femur. She seemed to be recovering from her injuries. And then later she passes away due to complications that arose from pre-existing medical conditions that she already had. And the testimony in the case isn't explicitly clear that that is legally a result of the collision, that is something that we can hold appellant criminally responsible for. And the jury received no concurrent causation instruction.
If she had died at the scene though, that would have been a collateral estoppel problem?
So if she had died at the scene, then you would have ended up in a better situation because you wouldn't have the appellant contesting in the trial court sort of the attenuation of the death. But there's still the issue of appellant's broader theme in his entire argument, which is that we don't prosecute people for accidents. Through each witness, he's cross-examining the person, getting any concession he can about, was this an accident? For the medical examiner, he was like, you ruled cause of death an accident, correct? And he goes, accident, accident, accident. He's cross-examining the police officer who investigated the scene. He says, well, you don't arrest people for accidents normally, do you? Like, you have, in the past, you have investigated accidents and not arrested anybody, right? And he asks a weird question right in the middle of that exchange where he says, and you don't file charges on someone without a mental state, do you? And the police officer doesn't know what he's talking about because that question is sort of nonsensical. Like he makes it sound like the person doesn't have a mental state. And the officer doesn't stop so that he's talking about culpable mental states, and he moves on to something else. And that's when he goes into all of the various ways that this might have been an accident, and we don't really prosecute people for accidents. And all of this sets up a closing argument where rather than going toward voluntariness or talking about particular risks that may or may not have been disregarded by appellant, it's all about there's no offense here. You can't prosecute this. If you decide that he's guilty, you decide that he's lying about his mental health and that the doctor is lying about his mental health. And if he actually has this mental illness, then this is just an accident. And if it's just an accident, then it's not prosecutable. In fact, at one point, one of the defendant's lawyers in the trial court actually argues that manslaughter is just a null set. She argues that manslaughter requires intent, but if the state had intent, it would have charged murder. So that's how you know that you can acquit of manslaughter, because there's no intent here. She says there's no evidence that he intentionally floored the gas pedal. And so, or well,
But if she's no evidence of intent to cause the accident and injure the one person, doesn't that preclude prosecution for the same reason against the other person?
If the jury necessarily decided that fact, that might be true. But it's not that specific, the way it's argued to the jury. It's not grounded in the charge. You can't prosecute people for this. And we never link up in the evidence. We never link.
So let me understand that though. Like, you're saying that you can't prosecute people for accident. You're essentially, if we're not saying that it's a decision on a culpable mental state, it's just jury nullification. That you're just saying that there's no collateral estoppel issue because there would have been jury nullification because they thought this is just not the kind of thing you prosecute people for?
I think it's easy to read the record that way. At one point during the closing argument, the defense attorney says it's not an excuse. He's talking about the mental health, and he says it's not an excuse. It's perspective. It's doubt. You know what I'm saying resonates with you, right? He's not linking this up to the charge. He's saying, look at how they've treated this person.
I guess my reason why I'm a little skeptical about that though is that if jury nullification is always a way to say the jury could have nullified as opposed to addressing it, then you'll never have a collateral estoppel argument because you can always say the jury could have just nullified.
That's exactly right, Judge Newell. And that's why the state, when I'm like, consider Ash, right? Consider the facts of Ash. Ash had a very clean record, right? There was not a single cross-examination question that wasn't challenging identity. And because of that, the court was able to say, we look at the record with reasonableness and rationality. That's the only rational path to acquittal. I can't go in on a record like Ash and say, well, you know, this robbing poker game statute is really unpopular. I don't think the jury really understood it. I don't think they actually wanted to convict him. And I think that was just jury nullification. If I were to come in on a case like that and say that, I would be completely gutting the doctrine. You would have no case where you could assert the doctrine. But this is different. Here, when you actually argue to the jury that the reason they should acquit is not because of any particular risk that was disregarded, but because what you're saying resonates with them and that we shouldn't be prosecuting people for accidents, you're assuming the risk that later on you're not going to be able to point to a necessarily decided fact. And that's the problem. The problem is that when you take a shotgun approach or a holistic approach in the trial court, and you're suggesting that maybe we just don't find this guy guilty for sort of abstract reasons, you're not going to have that record that gives you the necessarily decided fact about the culpable mental state.
Are you asking us to do something new by focusing on the jury charge as opposed to what was actually argued by the defense?
Not at all, Judge Erie. And that's an important point, is that this court just last year in Adams made it very clear that the place to start in these cases is the jury charge. And the reason that, that this court gave in that opinion makes a lot of sense. The jury charge is what authorizes the conviction or the acquittal. It's what tells the jury the circumstances upon which they are either going to convict or acquit the defendant. So if you're trying to figure out a particular discrete fact that the jury must have found, you have to start with what were the circumstances under which they could have reached the general verdict that they did. So it's really important to focus on the jury charge first, because that's what makes the verdict lawful rather than lawless. But also it's what allows us to apply our state substantive law, what the legislatures have the authority to pass, and filter it through double jeopardy-based collateral estoppel. If we don't start with the jury charge, then we're losing sight of the state substantive law. So to get back to Judge Newell's point about jury nullification, you assume a risk when you ask the jury to nullify, that you're not going to be able to identify the particular discrete fact, as is your burden on pretrial habeas and as is your burden in any double jeopardy claim. But consider if this case had gotten, with a focus on the jury charge, the voluntariness instruction, right? And they don't ask for a voluntariness instruction, and it makes sense in light of the broader strategy, because if you're just asking people to sort of abstractly think about how this was just an accident and he's sorry and now he's suicidal, and look at the state calling him a liar, if that's your strategy, you don't want to point people to what your actual legal argument would be, which is that he was not acting voluntarily when he did the acts that are alleged in the indictment. You would have to concede those acts alleged in the indictment and then point out, I'm saying that this mental health diagnosis that the person testified to, the expert testified to, is something that is similar to another condition that can cause a psychotic break. And when you have that psychotic break, we're saying that means that he was completely not in control of himself and everything he did was completely involuntary when he caused the collision. That argument is not nearly as easy for the jury to bite off on as, look how poorly the state is treating this person who has mental health issues. So it makes sense in the context of this case not to ask for that voluntariness instruction, not to ask for that clarifying language in the charge that would tell the jury what to do with your argument. But when you do that, you assume the risk that you're not going to be able to point out that particular discrete fact and use it for estoppel purposes later. So those are the other bases, to answer Judge Newell's original question. Those are the other bases on which you could have acquitted, the rational paths to acquittal. There was the attenuation of the—
To be clear, we don't even need to go off into the nullification thing if we say, look, there was another cause of death.
That's correct. Or the jury could have reasonably, rationally found that there was another cause of death, or that the cause of death was far enough attenuated to prevent the attachment of criminal liability, or that the cause of death was far enough attenuated that it wasn't a substantial risk from appellant's actions, or that it was a far enough attenuated cause of death that appellant can't be blamed for taking the risk or can't be blamed for being aware of it, that appellant wasn't necessarily aware of the risk. And that's what we have here. We have sort of an eggshell victim in the manslaughter case. She had all these medical conditions. She was 83 years old. And so while in some general sense, we know that flooring it down the wrong side of the road is dangerous, you can see a rational path to acquittal when the woman ends up dying from pre-existing medical conditions later in the hospital, 4 days after the accident, after they've already reset her femur and they thought everything was going to be fine. And you have testimony from the law enforcement officers at the scene. You have testimony from EMS saying, or not testimony from EMS, but the statement gets into evidence that we don't believe she's low sick. And they say that low sick is what they say when there's a decent chance of death. So right there at the scene, nobody's too worried that she's going to die, although obviously she needs medical attention. Then she goes to the hospital, and doesn't die for 4 days, or doesn't develop the complications for 4 days. And then they actually put her on life support. So she's not dead yet. She actually dies when they take her off life support. So without some sort of concurrent causation instruction, there's a rational path to acquittal based on the attenuation of the death on any of a number of different legal principles. So that's the alternative. Those are the alternative facts that could have been found by the jury. But where this court can really advance the jurisprudence in this case is by clarifying that the culpable mental state question in an aggravated assault case is a different question from the culpable mental state question in a manslaughter case. And this is particularly true where you're talking about two different defendants. One is whether you're substantially disregarding a risk that somebody is going to die, and the other is whether you're substantially disregarding an unjustifiable risk of bodily injury. And the gap, as I illustrated in my brief, is quite drastic between death and bodily injury, which is just any sort of bodily harm. So when we look at the way we do that in Texas, and we have recklessness as it modifies and distributes down the statute, these are both result-oriented offenses. What becomes important is the risk that's being disregarded. And because these are different risks to different individuals, different results, there is no identical issue that's going to be litigated when it comes to the culpable mental state here in this case. And for that reason, collateral estoppel does not apply. This court can write an opinion that clarifies all of that and reach the same result as if it addressed the fact that maybe there was more than one rational path to acquittal in this case. And I see I'm running out of time. Oh, Judge Erie?
Yes. What about the additional pleading requirements for cases involving recklessness and criminal negligence? Should we be concerned that we may be impacting those pleading rules and the fact that the state actually has to plead facts? Have those facts been settled upon? The facts that were pled to show recklessness?
That when we look at the indictments in this case, that's a good way of illustrating how we could have a collateral estoppel issue if the alleged acts, which are the same in both cases, operating a motor vehicle at a speed not reasonable or prudent, failing to control the speed of the motor vehicle, and failing to keep a clear lookout. If you were to say, couch the argument that was made here as voluntariness and say that none of those acts were voluntary, you still get to take advantage of collateral estoppel. So we don't have to be worried about the effect that it has on our pleading requirements. We just have to clarify the way this works in a collateral estoppel context. And I see I'm out of time, so I will reserve the remainder of my time for rebuttal unless there are other questions.
Thank you, counsel. You may proceed.
May it please the court, Chief Judge Keller, counsel for the state. I'm Michael Mola. I represent Christopher Rion, and I'm here to ask the court to affirm the opinion and judgment of the Court of Appeals in this case. The Court of Appeals has found that the trial court abuses discretion by denying the pretrial application for writ of habeas corpus. Listen to the state's argument. The state made several statements. For instance, one, they discussed, shaky evidence that the state presented. Cases, of course, in criminal proceedings are the state's to present. They're not the defense's responsibility to present that evidence. So if the state presented shaky evidence, that's the state's fault. And what I was hearing from counsel for the state was at first sounded like a legal sufficiency argument. We were hearing about whether, for instance, Ms. Parnham, died at the scene or whether she had pre-existing conditions. The jury has already determined, Your Honors, that my client or the evidence was legally insufficient to prove manslaughter. The jury charge, as Your Honors know, also contained an instruction for criminally negligent homicide. The jury rejected that as well. Trial counsel objected to a lesser included instruction of criminal negligent homicide, and the jury rejected that. Trial counsel talked about issues regarding whether, what the jury may have been thinking in its findings.
Mr. Mola?
Yes, sir.
Who objected to the lesser? Was it the state or the defense?
I believe the trial counsel did.
Okay.
Case. Look, regardless, Judge, obviously, as you know, the court is entitled, the court feels that there's evidence supporting a lesser included, that the court can insert the lesser included in the charge, but the jury rejected that. Counsel for the state talked about, what the jury may have been thinking, may have been deciding, but, Yeager versus United States, a 2009 Supreme Court case, I cited on page 68 of my brief. Yeager, on this issue of to determine what a jury necessarily determines, the courts have to scrutinize a jury's decisions, not the jury's failure to decide. Now, Yeager talked about, of course, consideration of hung jury counts are not something that a court should consider. But again, here, the jury found that the evidence was insufficient beyond a reasonable doubt to prove manslaughter and insufficient beyond a reasonable doubt.
Sorry, but counsel, aren't there reasons why? I mean, you're saying that we're not supposed to be getting into what the jury determined, but we are supposed to determine what the jury necessarily decided in order to determine whether or not there was a fact that they necessarily decided against the state that the state is going to rely on in the next proceeding. And there seems to be other rational ways the jury could have acquitted without deciding the issue that you're saying is precluded now.
Yes, Your Honor. If we decide, just like this court did in the case Adams, ex parte Adams, the counsel for the state cited, if you look at what trial counsel argued, trial counsel, he did argue on a matter of legal sufficiency that, this was an accident, this wasn't manslaughter. This was indeed an accident. The jury apparently agreed that it was an accident, but trial counsel focused on recklessness, and I don't understand the state's argument that the mens rea of recklessness in manslaughter is different than the mens rea of recklessness in aggravated assault with a deadly weapon. During trial counsel's argument, he didn't raise a separate ground for acquitting Mr. Rion, but in volume 5, pages 21 through 22, and then 28 through 38, he argued simply that Rion suffered a mental breakdown, and that rendered him not criminally liable for his conduct. Obviously, if a person does suffer a mental breakdown, they may not have had the mens rea to commit a reckless act, which is the only way that one can commit manslaughter.
Well, counsel, in
Yes,
your
sir.
opinion, is it possible for someone to potentially be reckless with respect to whether someone might be injured, but at the same time not be reckless with respect to whether somebody might actually die as a result of your conduct?
Well, not really, Your Honor, because recklessness is defined by Texas Penal Code 6.03, only has one definition. Aggravated assault with a deadly weapon and manslaughter are both result-oriented offenses. I agree with the state on that one point. And, recklessness is defined only one way. It's under 6.03C. And, a defendant, when they're indicted for an offense, Your Honor, they have to know, what standard the state is responsible for to prove beyond a reasonable doubt so they can prepare a defense. That's exactly what trial counsel did in this case. And so to say that, Mr. Rion could have been not reckless in committing a manslaughter, which is just a reckless cause of death, but could have been reckless in committing the aggravated assault when both indictments address the exact same instant accident.
Is
But
it,
as
is
a
it
result
actually,
of conduct, go ahead, Judge Newell.
oh, I was going to say but as I understand your argument, it almost courts including an idea of proximate cause to treat those two culpable mental states as different. You're saying, well, I have proximate cause to believe that this accident would have done this, but the proximate cause would be this, but it wouldn't be the murder unless I have someone that has all these injuries. So it seems like it comes back to causation, at least from my perspective, is you're going to look at whether or not the conduct at issue caused the injury. And that kind of, as the state makes a good argument, that we can't say that the conduct caused this death, and that or that there's a possibility the jury didn't believe that the conduct caused this death, and that's why they could still proceed on an aggravated assault.
Yes, Your Honor. To clarify, when I originally argued this case in the Fifth Court of Appeals, my argument was that because the jury necessarily decided facts, and those facts were that Mr. Rion did not act recklessly, and those necessarily decided facts form an element of the aggravated assault case. One of those elements is recklessness. My argument was that because this first jury in the manslaughter case found that Mr. Rion was not, or the state didn't prove beyond a reasonable doubt that Mr. Rion acted recklessly, then the state is stopped from prosecuting an aggravated assault case that he acted recklessly. My argument was that, well, obviously, if he did not act recklessly, he could not have acted intentionally or knowingly, which are the other two possible mens reas for aggravated assault. Now, the Court of Appeals disagreed with me on that argument. They said, well, look, we're not going to say that the state can't prosecute this case at all. We're simply going to say that the state is collaterally stopped from prosecuting this case based on a recklessness mens rea. So that, that's what I believe that we're discussing here. Again, the case law and the statute, I think, are very clear that if you act recklessly, in same transaction, same facts, the only things that are different are the complainants and the charges.
The statute, you've directed us to the statute itself, and the statute specifically requires a person to be reckless with respect to a particular result. And since these are both result of conduct offenses, we're talking about two different potential results, and the statute requires you to be aware of a risk of a result. So in a manslaughter case, certainly the result is the death of the victim. But in an assault case, you're not talking about a death. So I'm really struggling with this, and I hope you can kind of try to fill me in. How does a finding by a jury, if that's what they found, that someone may not have been aware of the risk of a death equate to a finding that they may not have been aware of a risk of injury?
Yes, Your Honor. I think the answer to that question is found in the jury instruction. In this case, the jury instruction, as I pointed out on pages 44 and 45 of my brief, it's on page 3, the supplemental clerk's record. It defines recklessly or reckless. The instruction given for a person to be reckless, there must actually be both a substantial and unjustifiable risk that the result complained of will occur, and that the person acting was actually aware of such risk and consciously disregarded it. And then the application paragraph asks a jury to find Mr. Rion guilty if it found that he recklessly caused Ms. Parnell's death by operating a motor vehicle at a speed not reasonable or prudent for the conditions then existing, or by failing to control the speed of the vehicle, or by failing to keep a clear lookout or control of said motor vehicle, therefore striking the motor vehicle occupied by the deceased. This is the same language, almost verbatim, that's in the indictment, Your Honor, for the aggravated assault.
I'm sorry, I just don't understand how that answers Judge Urie's question, because you still have the difference between death and injury. I'm sorry, I'm just not understanding that.
Well, Your Honor, I think it answers his question, because if a person, the jury found that the state did not prove beyond a reasonable doubt that Mr. Rion appreciated that unjustifiable risk. I mean, I believe.
Or that he didn't cause the death. I'm still on that. I don't see how they necessarily found lack of recklessness when the cause of death is really also an issue. How do you respond to that?
Well, Your Honor, the problem is, though, we don't, again, going back to the state's comment about the shaky evidence, we don't know for sure what the cause of death is, okay? But ultimately, if the jury found that, the state did not prove beyond a reasonable doubt that he acted recklessly in, for this manslaughter, I don't see how logically we can get to that it's possible that he could have acted recklessly in causing an aggravated assault when the complainants were in the same vehicle, and this is the exact same fact with just two different complainants.
But the issue, but for that, it's not that he acted recklessly, it's that he recklessly caused the death.
Right, yeah, they found beyond a reasonable doubt that he did not, or that they found that the state didn't prove beyond a reasonable doubt that he did not cause the death by acting recklessly.
But the jury is not finding that he didn't act, that he did not act recklessly. I mean, they're not saying that he wasn't reckless. They're saying he didn't recklessly cause the death.
Well, Your Honor, the problem is, though, again, if we go down that road and say that, well, he could have been reckless, that, let's say that if you're saying that the jury may have found that he could have been reckless, he just didn't recklessly cause the death, I think that problem is the state's problem for failing to present the evidence that they should have presented if they felt that he caused a death. And if the finding is going to be that Mr. Rion may have acted recklessly, despite what counsel argued, what the state argued, and wasn't a jury charge, but he just simply didn't cause the death, then there's no way that collateral estoppel could ever apply. Because here, again,
I was just going to ask, is the conduct at issue in the case where they were acquitted the same as it is going to be in the next, in the aggravated?
The conduct is the same. The result obviously is going to be different because, again, although manslaughter and aggravated assault with a deadly weapon are both result-oriented offenses, the ultimate result is different. But, what we're talking about when we say mens rea, the mens rea of intentional, knowing, or recklessly, we're talking about the defendant's conduct to get to the result. Here, the defendant's conduct to get to the result as a state prosecuted manslaughter was that he acted recklessly. Okay, he acted recklessly.
Go ahead. I'm sorry to interrupt you. I didn't know you weren't done.
Oh, okay. No, I was, just to finish the answer, Judge Newell's question. He acted recklessly, and the state failed to present sufficient evidence, obviously, that he acted recklessly or even with criminal negligence, because that wasn't a jury charge.
I just kind of don't understand why you're like, culpable mental states are inherently these metaphysical kind of decisions that can lead to a lot of different interpretations by jurors, as opposed to the conduct, which you're saying is the same. I don't understand why you're not just arguing the conduct was the same, so they necessarily decided against him on the conduct.
Well, I think that's what I said, Your Honor, and I apologize if I wasn't clear. The conduct that the state alleges in the manslaughter case and the aggravated assault case is the same, okay? And, the recklessness is an element of both offenses. Again, the ultimate result would be different because obviously manslaughter requires a death versus aggravated assault simply requires an injury. But, the focus of collateral estoppel, based on the case law that I've read and my understanding it, is dependent on the conduct if we're talking about the mens rea here, as again, in the case that the state is largely relying on, Ex parte Adams, this court found that, if a defendant is acquitted on a defense of a third person theory after stabbing a person in a fight, collateral estoppel does not bar subsequent prosecution for stabbing another person who was not fighting. See, these are two different results and two different points of conduct. Obviously, if you are acting in a defensive way, either under section 9.31 or 9.32, there's a big difference if one person that you injured was trying to attack you, either with or without deadly force, but the other person was not trying to attack you. So, the conduct is different in Ex parte Adams, and the result was different as well. Or in any case, the conduct is different, the result may be the same. But again, here we're talking about, Your Honors, what the defendant's conduct was, and his conduct was recklessness. And again, I don't, because, otherwise, if we start parsing it out more and, speculating on what a jury might have been thinking, because look, a jury is charged, unless a jury is given a special interrogatory, a jury is charged with either finding a defendant guilty or not guilty. Here they found him not guilty.
Excuse me, Mr. Muller.
Yes,
it just seems to me that Ryan was charged with aggravated assault and manslaughter.
Yes,
and
sir.
So when the jury found Ryan not guilty regarding the manslaughter charge, it was deciding whether Ryan recklessly caused the death of Parnell, not whether Ryan was reckless generally. If it didn't cause the death, he could have been reckless all day. And they still find him not guilty. But here, in the aggravated assault case, the jury would be asked if Ryan recklessly caused bodily injury to Laura. And for collateral estoppel to apply, both prongs must be satisfied. Here, prong one, even if it was satisfied, prong two wasn't.
Well, Your Honor,
Do you have an answer to that?
yes, sir, I do, Your Honor. Under Taylor and Reynolds, which are cited in my brief, you have the relevant facts that, whether Rion acted recklessly were necessarily decided, but prong two is whether the necessarily decided facts form the essential element of recklessness in the pending trial for aggravated assault. So again, if we start going down the road of, we're going to decide in a manslaughter case, for instance, this is a manslaughter case. If we decide, for instance, here that the defendant may or may not actually have caused the death, therefore he could have been reckless, but he just didn't cause the death, so we find him not guilty, then in any case, then what the court would have to do is consider what evidence the state presented. Here, again, the state simply failed to present sufficient evidence showing that a client was guilty. Again, shaky evidence. So, it seems to me what the state's asking the court to do is bail it out for not presenting a good case. And again, in the first case, Your Honor, again, he was also found, the jury also rejected a criminally negligent mens rea as well.
But it still had to do with the cause. I mean, the cause of death. And if they went off on the cause of death, the guy could have been, negligent all day, and he still would be entitled to a not guilty verdict. And regrettably, we aren't privy to the jury's deliberation. And we don't know. All we know is that he was found not guilty. And the question is whether or not collateral estoppel applies under those circumstances.
And Your Honor, again, going back to Yeager versus United States, to decide what a jury necessarily determined, we have to simply look at what the jury's decision is. The jury's decision here was guilty or not guilty. They weren't giving a special interrogatory. Now, if they'd been getting a special interrogatory where they were asked to say, okay, do you find recklessness, and do you find that the recklessness caused the death, yes or no, then we'd be talking about a very different thing. That's what sometimes you find in civil cases.
Civil cases, yeah, sure.
But Your Honor, in a criminal case, there simply was no. We don't usually have special interrogatories, and here there was no special interrogatory. All we know, the jury necessarily decided that Mr. Rion was not guilty of manslaughter, and it decided that he wasn't guilty of criminally negligent homicide. Now, that's all we have to go on.
I just have one question further, Judge Keller, if I could ask one last question. Thank you. Mr. Mola, do you perceive any impact on our decision in this case related to the application of Article 21.15 of the Code of Criminal Procedure requiring additional pleading of facts when recklessness or criminal negligence is alleged? And I'll let you answer.
Your Honor, if one issue that has quite often come up in criminal cases is that the state, has, over the years, in my opinion, become more and more vague in how they plead a case. Pleading simply means an indictment. Now, the state specifically pleaded, for instance, that, he acted recklessly, and they said, well, maybe he did or didn't actually cause the death. We're just talking about whether he acted recklessly in the actual conduct versus the result. That'd be one thing. But the state did not indict the cases that way. The indictments were the same, with exception of the crime and the complainant.
Okay, thank you. Your time is up. Thank you very much.
Thank you, Judge.
May it please the court, Josh Vanderslice for the state in rebuttal. I want to start by getting back to Judge Erie's point about the pleading requirements, because I think one thing that raises is the fact that conduct is not isn't in the manslaughter statute. You just have to recklessly cause the death. We have another statute that forces us to plead that conduct, which helps to satisfy notice provisions and let everybody know what we're talking about at trial. And we have to prove that as well once it's in the indictment. But conduct is not actually the actual conduct is not in the manslaughter statute. So you can't really argue that recklessly in the manslaughter statute is not going straight to the result of the offense. If you focused on the conduct, Yes.
Do we even have to get into that if we ultimately just say the jury could have acquitted because of the cause of death? If we say the
No.
jury could have acquitted on the cause of death, then they haven't necessarily decided an issue and they wouldn't be collaterally stopped from prosecuting, the state wouldn't be prosecuting this other.
That's exactly right, Judge Newell. And Judge Kiesler was exactly right earlier when he was pointing out you have to satisfy both prongs of collateral estoppel, and it's the defendant's burden to satisfy both prongs of collateral estoppel in the pretrial writ context and as a matter of double jeopardy jurisprudence. So if you don't meet one of them, you don't have a collateral estoppel claim, your prosecution isn't precluded, you're done. And you know, I understand Mr. Mola's point about the shaky evidence to be that, well, this lets the state off the hook if they don't prove something in the first trial. But that's exactly right. Like, that is the state's problem, right? The state suffered an acquittal because of that problem, potentially. That's how the state gets punished for not presenting the adequate evidence. But when you're looking at what the jury necessarily decided, you also have to look at the whole record, Ash says, with reasonableness and rationality. If you take the facts of Ash and you don't present any evidence of a theft, but the defense is all identity and just whole hog on identity, well, he can't walk into court and say that jury definitely acquitted on identity because the state didn't produce any evidence of one of the key elements of the offense. So there's no real problem with that because we're talking about what the jury necessarily decided. We're not talking about an equitable estoppel at this point. We're talking about a double jeopardy based estoppel.
Counsel, does it matter for double jeopardy purposes that appellant requested that the cases be tried together?
It does not in the context of this case. It would matter in the context of Currier, right? All it means that he wanted to do it together is that he's not barred from bringing his double jeopardy claim on pretrial writ the way Currier was. Currier is an estoppel to an estoppel opinion. You're stopped from raising your estoppel claim. He's not stopped from raising his estoppel claim. He's just wrong on the merits.
Thank you.
So that brings me to the broader conflict that I think I heard a lot of questions about from Mr. Mola, and that is reckless is, we agree these are result-oriented offenses, and recklessness in the statute, particularly in aggravated assault and manslaughter, it's not in the abstract. It modifies a particular result. And nowhere in the briefing or an argument has Mr. Mola been able to identify that particular elemental fact, that discrete horrible fact found by the Parnell jury that precludes the prosecution for consciously disregarding a risk of bodily injury. And the reason is because that's not going to be in that case, right? It's a manslaughter case, and the element was different. The argument on the identical issues prong from appellant is that, well, once you've been acquitted of being reckless in particular circumstances, you can't ever be tried out of that same transaction for another recklessness offense. But that has two problems. First, that's not how culpable mental states work, because culpable mental states are narrower than that. They modify the acts or the result, they don't modify the actor. So he can't just say, I'm not a reckless person. That's not the issue. He wasn't acquitted of being reckless. He was acquitted of consciously disregarding a substantial risk that Parnell would die and causing that death. I see I'm almost out of time, unless anybody has any other questions. My closing point would be that appellant's position is essentially, when he's focusing on all these elements, he's focusing on this same conduct or same transaction approach. And that approach was litigated in Ash, and it did not carry the day as a matter of collateral estoppel jurisprudence. You can look to the side opinions for that. It's also been litigated as a matter of double jeopardy jurisprudence. And there was a Grady test at one point, a same conduct test. That test has been disavowed in a state called US v. Dixon. So at this point, the questions were different, and because the questions were different, there's no estoppel.
Thank you, counsel. The case is submitted. The court will stand in recess until noon.